Hello, everyone. Good morning, good afternoon, wherever you might be. My name is Josh McCullough. Thank you for joining us here for today's event brought to you by Corporate Payroll Services. Today, we've got a lot of information. Our topic is layoffs, furloughs, and recalls. We are excited to have Kara Govro with us. We'll talk a little bit more about Kara here in just a second before I turn it over to her. Before we do that, let's cover a little bit of housekeeping, webinar basics here. You will get a copy of the slides and a recorded version of the webinar within about 24 hours, so keep an eye off on your email inbox for that. About halfway through today's webinar, we're going to do a couple of polls. We'd really appreciate your participation in those. And they are built to share with you the results, so maybe it provides some interesting insight for you as well. So we would love to hear from you in the polls. We do have a bit of a smaller event. We've intentionally kept it smaller so that we are able to keep an eye on your questions. So we will do our best to maybe pick off a few of those. If you do have some questions, make sure you use the Q&A box instead of the chat box. That just lets it be as visible as possible to our presenter today. With that, I am going to turn it over to Kara Govro. Kara, really quick, Kara is an employment law attorney, compliance expert, has really dove into all things COVID-19 related in terms of legislation and the practices businesses are having to tackle through this challenge, and she's got a lot of great information for you this morning. So with that, Kara, take it away.
All right, thank you. Hello, everyone. It's nice to be here with you. Happy Thursday. We're almost to Friday of a short week. Hopefully you've got good plans for the weekend. But never mind that. Let's talk about layoffs, furloughs, and recalls before we get to the end of this work week. So I'm going to talk mostly like paperwork for these first three bullets and sort of compliance things you need to think about and nitty gritty. And then in the final section of the webinar, I'm going to talk about the sort of bigger issues about deciding who to lay off, who to recall, or who to bring back for that matter. And those are perhaps actually the stickier, more dangerous areas as opposed to the paperwork stuff. So hopefully all of these sections will be interesting to you. Like Josh said, we have a small enough audience that I'll be able to answer questions. So if you want to send those my way, feel free, use that questions and answers box. I'm also happy to answer questions about the FFCRA or workplace safety in general. So pretty open to whatever you want to talk about. All right, let's talk layoffs. So what employers need to know about layoffs is that they're really just terminations at the end of the day. The one difference is sort of the ease with which the employee will get unemployment insurance. If they say it's a layoff and you verify it's a layoff, that's sort of the end of the story. If they are terminated for cause, they'll probably still get unemployment insurance, but there could be some argument between you and them about whether they sort of deserve it or qualify. So that's really the only functional difference, is that it might be a little bit easier to get unemployment insurance, which I'll call UI from here on out. And they just sort of know that they're not going to have to fight with you about that. Otherwise, it's all the same. So we need to give final paychecks to people we've laid off, and we need to do it within the time period required by state law. So some states require that you give them the paycheck on their way out the door, like California. Others require that you do it in about 72 hours. Well, it's not about, but 72 hours or some other number. Maybe it's 5 business days, maybe it's 2 business days. And then others won't say anything at all, in which case you should pay them by their next regular payday. Like if they're on, direct deposit, you can just leave them on direct deposit and pay them on that time frame. You want to make sure with this final paycheck that you're including PTO if that's required either by state law or by your own policies. So if that's something you usually provide, you'd want to do that this time around as well, even with a layoff. If you say we provide payout of PTO termination, that will include a layoff, including as well as any other kind of termination. We also want to make sure that we're not taking any illegal deductions from that final paycheck. So there are a couple ways a deduction can be illegal. First is that the deduction itself, for the reason you took it, was not okay. So certain states say you can only take a deduction if it's for the employee's benefit. So if they, failed to return a laptop or failed to return a uniform, it's not for their benefit that you've taken a deduction. Taking a deduction, for instance, like for medical insurance, that would be for their benefit. So you want to check state law and make sure you can take the deduction at all. Then state law might say that you need to do certain things, like get their permission in advance in writing. So make sure you jump through that hoop if it exists. And then finally, you want to make sure that the deduction doesn't take them below minimum wage or overtime on that final paycheck. Let's say you've given them a laptop, they signed something that said, they'll give it back or else be subject to a $500 deduction, and now they haven't returned the laptop. So, you've done all the things required by state law, but if taking $500 out of their final paycheck cuts in to minimum wage or overtime, then we've got a wage violation. Certainly under the Fair Labor Standards Act, but also quite possibly under state law. Okay, what else? Notice requirements. We need to tell employees, or I should say we probably need to tell employees that they're eligible to file for unemployment insurance. So some states required this pre-COVID. They had a form that you could give out to people when you're letting them go. Other states are requiring this now because the CARES Act required that states tell employees that they can apply, and the states decided to pass that requirement on to employers, which makes sense. A lot of states haven't written that law yet because writing law doesn't always happen very fast. So I would say just do this anyway. Like, don't even worry about looking up state law. Just go ahead and tell people that they have a right to file for unemployment insurance claims or unemployment insurance benefits. I would also suggest that you provide additional information to them. If there are links to, really helpful guides or a claimant's handbook or something, you can give them that link on their way out the door. Maybe they're not computer savvy. Maybe they're more computer savvy than you are. Either way, it's sort of a nice gesture to point them in the direction of some of the things they'll need, because they're the one that's going to be, particularly stressed out at this exact moment in time. You may also want to determine if you have any other UI obligations. Right now, though, we're talking about a layoff, which is really just a full termination. So generally, you don't have additional UI obligations other than to sort of answer any letters or requests that the state sends to you after somebody files. You'll also need to provide employees with information about continuing their benefits if you offer benefits. So if you don't offer benefits, don't worry about Cobra at all. But if you do, then we'll need to tell them how they can continue those. So Cobra is a federal law that applies when you have 20 or more employees, but states have something called mini Cobra. I think all but 1, 2, or 3 states has mini Cobra, and that applies when you've got 1 or 2 employees to 19 employees, so it really covers the gap there pretty well. Likely you outsource Cobra, so you're going to notify your administrator, your health insurance plan person, and they're going to take care of the election notice that the employee needs to get. You have 30 days to tell your administrator that the person is gone, and then they have 14 days to send the election notice. If you wait the full 30 days and they will wait the full 14 days, the person will almost certainly lose coverage in that time, which is a bummer. Even though Cobra will be retroactive, it's a real pain to sort of deal with that process. I've had some friends go through it and it's not great. So if you can save them from that by being speedy and letting your administrator know like the day or the day after the person is laid off, they can get that ball rolling, and then maybe they won't lose coverage at all, and that would be good for them. If you can provide the election notice yourself, you're welcome to do that. So that's something that you may be able to provide during their layoff meeting or their termination meeting, so they have that information right away. I'd also recommend that if you did have health insurance, they did have health insurance with you, and it looks like they're either going to go to Cobra or lose it, you might want to tell them about the health insurance marketplace options available. So these are things that may be less expensive than Cobra. And basically there are health insurance plans out there to be purchased even if you're not employed. Most employees will go through the federal health insurance marketplace, but there are 12 states and DC that run a marketplace at the state level. So you can figure out if you're in one of the states that does that, and basically just give employees a link, either to the federal marketplace or to the applicable state marketplace, because they will have the ability to use a special enrollment period to do that instead of Cobra, because that could be significantly less expensive than Cobra. So that's just an option that's available to them. And I think it would be basically nice of you to let them know that that's out there. People who have, sort of always had health insurance from their employer may not even be aware that that option exists. So I've covered a lot of this, but again, it's sort of to be nice, to be helpful, to reduce their stress level at this horrible time. You may want to provide some other resources. So links for the State Unemployment Insurance Department, possibly link them to the governor's website or the, state health department, so they can sort of follow along for themselves and see how things are reopening and what benefits might change or be available to them. You may want to link them to local food banks or other charities that are helping people out right now, as well as give them, a link to renters resources. So there may be places that are helping people pay rent. It may be that the state or the city has stopped evictions for the time being, then that might be useful information for them. Again, it's all sort of about reducing their stress level. So if you can do those things, I would encourage you to. Also comply with WARN if it applies to you. So WARN is a federal law. It stands for Worker Adjustment and Retraining Notification Act, and it requires employers to provide 60 days notice if they're going to do a really big layoff. So this applies when you're closing a work site, like a whole work site that has 50 or more employees. It also applies when you're doing a mass layoff of more than 50 employees, or at least 50 or more, and that accounts for 1/3 of the worksite's total workforce, or you're laying off 500 or more employees at a single site of employment. So, in most cases, WARN is not going to apply to your sort of standard small business, but if you do have 100 or more employees and you're doing a really big layoff, check out WARN. Also, a few states do have a mini WARN, which is kind of like mini Cobra. It's way less common than mini Cobra, but it's still something that is worth checking out. And we do have that information available on the site. If there's a state mini WARN, we've got that covered. It doesn't apply to layoffs that are less than 6 months. So if you're really just furloughing somebody, for 6 weeks until business is better, we don't need to worry about WARN. And there is an exception for unforeseen business circumstances. So if at the very beginning of the whole pandemic, when your state initially shut down, if your state shut down, if you had to close because you're a non-essential business and you laid off everybody, that would be an unforeseen business circumstance. We did not have 60 days notice that there would be a global pandemic that would totally shut down the economy or large swaths of the economy. So that would be a reasonable exception. But right now, if you're forecasting for the future and seeing that there's going to be a significant business downturn, and you do think you'll be doing a mass layoff, I would not rely on that exception because at this point, we're not really surprised anymore, and we may have the ability to give that 60 days notice. Okay, let's talk furloughs now. They're a bit like terminations for the employee, less like a termination for you, the employer. So what are the differences? Well, during a furlough, an employee is still on the books. And there's no legal, definition for furlough that's like really precise. Furlough could actually mean a reduction in hours, or just that you're like furloughing people on Thursdays and Fridays. It doesn't necessarily mean that you're sending them home indefinitely with 0 hours. So just FYI, furlough does have, kind of whatever meaning you want to give to it, but it's not a layoff. Either which way, the employee is still on the books, right? So we don't need to do final paychecks, and we don't need to do final PTO payout. There's a little bit of an exception for PTO payout, at least in California. So California requires that paid time off or vacation or personal days be paid at the end of employment. And a few other states require that as well because they consider them vested wages. If you're in one of those states and you're doing a furlough, your letter to the employee should include either the date you intend to bring them back or the thing that will trigger bringing them back, such as lifting of, the order to close business. So maybe that's phase 3 of the 5-phase reopening in your state. So if you're furloughing somebody, or if they're on furlough now even, providing this information, even if it's a little bit late, can't hurt. I said that a furlough feels pretty similar for an employee because they will not be getting any income and they will be eligible to apply for unemployment insurance. That surprised a lot of people probably 8 weeks ago. Now, employers have all learned quite a bit about unemployment insurance in the meantime. So yeah, employees who are furloughed, even with reduced hours, will generally be able to apply for UI. They may also lose health insurance coverage. Generally, plans will say something like employees are eligible when they are regularly scheduled to work 30 hours or more per week. If not, then they're no longer eligible and they'll lose coverage. That's a pretty common provision. It's not, your provision could be different. Your plan could read differently. So I'm not saying that that's what's in your plan, but that is extremely common. So if the person is furloughed, maybe you reduce their hours to 20 per week, maybe you sent them home for the next 6 weeks, chances are they would lose health coverage if you're actually following the letter of your plan to the letter. That said, even if your plan document does seem to make it clear that they're going to lose coverage, there may be some new flexibility provided by the carrier, either out of the goodness of their heart or because the state made them do it. So a lot of carriers are agreeing to changes right now, allowing employers to reduce the number of hours or the regularly scheduled language to keep people on health insurance while they're furloughed, or the state is requiring that carriers do that. So that's something you can definitely check into. It's also possible that if you're an applicable large employer, meaning you've got 50 or more employees and you're offering health insurance because the ACA requires it, that you're using something called a look-back measurement period to determine eligibility for group medical coverage. And in that case, there may be some employees who are considered to be in a stability period right now or during the furlough, and they'll continue to be eligible even if they don't have the generally required number of hours. If this isn't ringing a bell for you, if these terms are like totally foreign, don't worry about it. But if ACA look-back method sounds familiar, this is something you can check out to determine if your people will actually lose coverage. If none of those potential continuation scenarios apply, you're not using the look-back method, the carrier isn't expanding, your ability to cover people under the plan, then we're back where we were with a layoff. And we need to provide that Cobra Notice, or really tell our administrator so they can provide the Cobra Notice. And once again, I would recommend pointing employees toward the state or federal insurance marketplace so they can maybe find something less expensive. We once again want to tell employees that they have the right to file for unemployment insurance. Doesn't mean they're guaranteed to get those benefits, but we should tell them that they can. And you may also want to determine if you have any unemployment insurance obligations during a furlough. So one of you actually chatted in that you have to file partial claims every Friday for a team, that's furloughed right now. And I don't know what state you're in. If you want to tell me what state you're in, I'm actually very curious. I know that Georgia requires that you file on behalf of furloughed employees right now. That was the only state I knew of at the time. Oh, yep, this person's in Georgia. Okay. So as far as I know, Georgia is the only state that requires this particular thing. But it may be worth it to check out, basically spend some time on the state unemployment insurance site, regardless of what state you're in, because you may have some obligations that you were not aware of before. Gold Star, once again, learn about what partial unemployment means and what work share programs are. Those are terms that were pretty unfamiliar to a lot of us a few months ago. Partial unemployment was available in most states. That's where if somebody's hours are reduced, they can still make a claim and get, a little bit. Workshare is sort of a different program that was less common and is now being pushed because of the CARES Act and the federal unemployment insurance benefits that are available right now. So sort of understanding this stuff yourself will help you, answer questions. And somebody asked, what's the added cost to an employer for each layoff, and how's that determined? By annual payroll, weekly payroll, or something else? I'm going to guess as to what you're asking about. So when you have a high turnover rate, the state unemployment insurance tax may be higher for you. So it's called a SUI rate. It applies to employers. You don't pay unemployment insurance directly out of pocket. So when somebody goes and they claim UI, it's not like the state is going to send you a bill and make you pay it dollar for dollar. It's really an insurance program. So you pay into it over time. And most of the employees who leave you probably leave you for a different job. So they're not even going to claim unemployment insurance. So you don't have to pay, full price. You pay a little bit. And then when employees do need to access it, it's available for them. And it doesn't come back to you as a bill. That said, if your turnover rates are really high, the state will start charging you more. They'll charge you a larger tax, a larger insurance premium, because it's more likely that your people are going to go tap into that benefit. Just like if you crash your car frequently, your insurance rates for your car are going to be, through the roof. Right now, though, a lot of states are sort of suspending increased rate increases based on COVID-related layoffs. So if you're sort of panicking that your SUI rate is going to go up because you've had to lay off so many people, there's a good chance that that actually won't happen, because the states realize that turnover right now is not the employer's fault for being, lazy about hiring and terminations. It's the result of a global pandemic. So hopefully that sort of answered your question. I've got a slide here that you've seen before about providing additional resources to employees that you have laid off. The bottom two bullets are new. So one is about your employee assistance program. If that's something you have, if that rings a bell, that might be something you want to point your furloughed employees towards. It's not always bundled with health insurance. So even if they did lose health coverage, they may still have access to your EAP. And this is something that provides an assortment of resources and connections for employees, including oftentimes maybe 3 to 6 free counseling sessions, if that's not something that's readily available under your regular plan. Also, make sure they've got contact info for your payroll and HR people going forward. That's good. Don't make them dig around online or wherever to try and find a good phone number for your HR and payroll departments. A final thought on this topic is to keep in touch with employees who are furloughed. So I would recommend talking to them weekly. This doesn't mean, when I say talking to them, I don't mean calling them on the phone individually and chatting it out. I mean like posting something on your intranet or sending a mass email, just so they know what you're thinking. So, if you think a month from now you're going to bring back 50% of your workforce, maybe you've got 25% back right now, and you think you'll bring back another 25% in 2 weeks, just letting people know that will make them feel a lot better. Likewise, if you've brought 50% back now and you don't think you're going to bring back anybody else in the foreseeable future, let them know that as well. Really kind of get on with layoffs if you think that layoffs are in the future, so people can start planning for themselves, right? We don't want to string people along, letting them think that they've got a job when they don't. We want to sort of release them into the wild so they can start thinking about their own future. But assuming you are going to bring people back, communicating what you know, even if you don't know much at all, will help them out. Sort of like if you've ever had somebody go out on an FMLA or an ADA leave and you didn't know how long it was going to be, and they're really not communicating with you, you sort of start to wonder if you still have an employee. Employees are feeling the same thing. They're wondering if they still have an employer. So keep in touch any way you can. All right, I'm going to turn it over to Josh for a couple minutes to do a couple of quick polls.
Awesome. Thank you, Kara. I'm going to go ahead and launch this first poll. Let me see here. Okay, the question is, it should be up on your screen now. Which best reflects your outlook for your business over the next 3 months? And there is a range from very optimistic down to very pessimistic. So we would appreciate your participation, and I will be sharing these results with everybody. So please let your voice be heard here. While you are putting in your votes, I'll go ahead and remind you, we will be sending out the recording and the slides. Give us about 24 hours to do that. And it looks like several have already been using the Q&A box, but just as a reminder, if you have questions for Kara, please submit those through the Q&A box. So we are at 50%. I'm going to give this 3 more seconds. 2, 1. Okay, great. And I will share the results. So looks like in this situation, unfortunately, somewhat pessimistic is the leader, followed by, neither optimistic or pessimistic, somewhat optimistic and very optimistic. Good to see that very pessimistic is the last place vote there. But no matter how you're feeling here today, our hope from corporate payroll is that this information can maybe put you in a better situation and help you to get through some things that are challenging. So we hope you are finding value in this. So I'm going to stop sharing that, and let's launch poll number 2, and then we will get back to Kara's content. So this poll, a little bit for us as well, we are always interested in what topics you are feeling like you could really use more information on. So the question is, what topics would you most like to learn about in future webinars? A few of these are topics we're covering today, but if you would still like a deeper dive on these topics, feel free to indicate those. But you've got handling COVID layoffs and furloughs, recalling employees, legislative guidance, creating safe workplaces during COVID-19, engaging your workforce through COVID-19, and then OSHA guidance and requirements related to infectious disease. This is multi-select, I believe, so if you would like to indicate more than one of these, feel free to. We're at 25%. I'm going to give this 5 more seconds, and then I will share this. This is very helpful for us. We can kind of guess what people are needing, but we always like to hear it straight from employers. So thank you very much for your participation in this. We're almost at 50%. 3 more seconds. 3, 2, 1, and I will share the results here. Looks like the clear or the close leader is creating a safe workplace during COVID-19, followed by legislative guidance, and then the remaining issues, except for recalling employees, came in pretty even. So interesting feedback there. So, well, thank you for participating in that. We hope that's somewhat insightful and for you. So with that, I will turn this back over to Kara for the second half of today's content. Kara?
Okay, let's take a look. What do we have now? Recalling employees. Okay, this part is a little bit more fun. One of you asked if I could talk about the Paycheck protection program, and unfortunately I don't have any information to offer on that. So just in case anybody is hanging out for the scoop on PPP, that is not something I'm covering today. We've sort of had to, pick our areas of focus, and I've got a lot of them. There are a lot of things I can speak to, but unfortunately, state-specific unemployment insurance regulations and the payroll or Paycheck Protection Program are not among them. But hopefully, we've still got some more good information about recalling employees in here that will be helpful. If we're bringing somebody back after a layoff, like full layoff, they were terminated, what do we need to do? Well, for the most part, we're going to treat them like a brand new employee because they are a brand new employee. The relationship was fully ended. They were done with us, and now they're back. So we're going to go through the usual offer letter, benefits and enrollment, reporting to the state that we have a new employee, and most of the new hire rigmarole. They should fill out a new W-4. They might say to you, I've got a W-4 from 3 months ago, or 2 years ago, can't you just use that? Well, there's a new W-4 this year. My impression is that nobody likes it. It's quite a bit more complicated. So the returning employee might really want you to use their old W-4, but you can't. You need them to fill out a new one. Otherwise, you're going to have to do special things to file for them, or not really special things, but I think you have to file for them as an individual with a single exemption. Don't quote me on that, but basically, at the end of the day, they need to do a new W-4, whether they like it or not. What they may not need to do is a new W-9, or sorry, a new I-9. That's the one exception to treating them like a new hire. So if their original I-9 is not more than 3 years old at the time of rehire, then you can just fill out Section 3. Pretty easy peasy. What about recalling employees from furlough? Well, really, they've been on the books the whole time. We never told the state that they were terminated, so we don't need to report to the state that we have a new employee. They should be in the payroll system. So really all we need to worry about is their benefits if they lost coverage. Maybe one of those, exceptions applied and they didn't even lose coverage, in which case, excellent. We don't have to do anything at all when we bring them back in terms of paperwork, but probably they'll need to get re-enrolled. You don't need to make them go through the entire waiting period, though. You should be able to re-enroll them on the first of the next month. If you want to check with your carrier on that, you most certainly can. From what I've been told, generally when people call and check with their carrier about it, the carrier says, hey, just make your own policy and follow it. When you do bring somebody back from furlough, though, an offer letter is important. If for no other reason, then we will get documentation of whether they are coming back or not. That said, I do think we should cover more than that. So if you've changed anything about their position, their pay, their reporting structure, their responsibilities, you should cover that in the offer letter. We want them to know what they are returning to, and for them to have the possibility of turning us down. If we're planning to bring people back 3 weeks from now, but at a lower rate of pay, don't wait until they come back to tell them about the lower rate of pay, because if they decide to quit on the spot, then you don't have an employee, and you could have been planning for that 3 weeks ago if they declined your offer to return based on the fact that you intended to have a pay cut that they couldn't tolerate. I'd also encourage you to list any steps you're taking or policies you're implementing to keep the workplace safe. So this is sort of twofold. Telling them what steps you're taking will make them feel more comfortable returning to the workplace, and telling them what policies you're implementing will help them prepare ahead of time. So, mentally prepare and physically prepare. If you're going to want them to wear a mask all day, maybe they want to find one that won't fog their glasses. If you are going to, move desks around so people are at least 6 feet apart, then they know they're not going to return to their usual workspace, and they can sort of, have that in their head ahead of time. And hopefully you won't hear quite as much whining when they return on the day of. So 2 reasons to sort of cover that stuff. And then finally, like I said, for no other reason, we want them to indicate if they're coming back or not. And one of you chatted in that, you try to bring somebody back and they declined. And so you sent the offer letter and the email correspondence to the unemployment office. That's perfect. You've really covered your bases if you've got this in writing. So that's what we're going for. And we have actually created a recall letter for you that you can use. We've done the heavy lifting. You just fill in some blanks. And that one at the bottom, it says, yes, I'm coming back. There's a checkbox. Or no, I'm resigning. There's a checkbox. And then below that, it says, hey, if we don't hear from you at all within X days, we'll assume that you're resigning. So that really helps you sort of cover all your bases. One of the main questions we're getting right now is, what about employees who don't want to come back? Well, it depends on why they don't want to come back as to whether they're going to get unemployment insurance or not. Of course, any employee has the right to not come back. We have at-will employment relationships here in the United States. Unless they're under contract, they're free to quit anytime. What employers want to know is, are they going to get UI when they refuse to come back, or say they want to stay on a furlough? Do I have to let them keep furloughing? You don't. You don't have to let somebody stay on a furlough in almost any situation. However, they will probably continue to get benefits if they refuse to come back for one of these reasons. If they're high risk and you can't accommodate them, they can probably keep getting UI. So, if they have diabetes and a heart condition and their healthcare provider has told them they should not go back to work right now, and you can't arrange it for them to work from home, then if they decline the offer to return, they'll probably keep getting UI. If they have children to care for whose schools are closed because of COVID, or they're caring for people who are sick or quarantining because of COVID, and that's why they can't answer your recall letter at this exact moment, they'll probably keep getting UI. And if you're not offering a workplace that meets basic safety guidelines right now, then they'll probably keep getting UI. You can report them if they've told you, hey, I'm making more on unemployment insurance, I don't want to come back, or I'm just kind of afraid, I'm not really comfortable with it, and your state actually may require that you report those people. So if you're asking somebody to come back from a furlough and they're giving you kind of a lame reason, you can let the state know that. They are not entitled to collect unemployment insurance benefits just because they don't feel like working or because that pays better than their job. And some states are actually creating reporting systems for this exact purpose, like hotlines, basically. So that's another thing that if you just go spend an hour on your state UI website, you'll probably learn about that option or that requirement if it exists. Somebody asked if you can require a doctor's note to confirm that someone is high risk. And the answer is yes. I'll cover this a little bit more a few slides down the road, but if somebody's asking not to come back right now when you want them to return, what they're really asking for is a reasonable accommodation under the Americans with Disabilities Act. That applies when you've got 15 or more employees. And some states have a similar law that applies at a lower number of employees. So if someone comes to you and they say, I'm high risk, I don't want to come back right now, what they're really asking for is a reasonable accommodation. They don't have to call it that, but you should identify it as that, which means you need to engage in the interactive process under the ADA. You have lots of info about all of that, and you can ask for a doctor's note. Good question. Okay, let's talk about selection criteria. So this applies to laying people off, full termination. It applies to who you're going to furlough. It also applies to who you're going to recall. So we're sort of spanning all areas there. And unless you're letting everybody go or bringing everybody back, we want to document why we've selected certain individuals. So assuming you're only bringing back 25% or 50% of your workforce at once, we need to be able to explain the non-discriminatory criteria we used to pick those people. Why them and not their colleagues? The first thing you'll probably want to do, when planning to bring people back in mass, is consider your business needs. This seems really obvious, but employers have different levels of wanting to have things explained to them. So here we are. First up, consider your business needs, right? How many people do you really need to operate right now? I would encourage you to lowball. If you bring everybody back and you don't need them and you have to furlough a bunch of them again, but they, finished off their unemployment insurance claim because they'd been put back to work 40 hours a week, restarting UI claims can be a real nightmare, especially right now in certain states whose systems were coded using some programming language from the 70s. The last story I heard in Oregon, where I live, was that, like someone had called literally 8,000 times and gotten a busy signal every time. This was over the course of many weeks. They obviously had nothing better to do, but it was a nightmare. So if you can not cause people to end their claim and then have to restart their claim, that's better. So start with fewer people than you think you might need and go up from there. If you lived through the 2008, 2010 or 12 recession as a business, you might know how a diminished economy is going to affect you. So you can sort of do a historical review and see what happened back then. Also consider what new skill sets you're going to need to have for the future. So maybe you're a bakery and you're not going to be doing a lot of catered events this summer, but you might be doing significantly more deliveries. So sort of plan ahead of time. And then this is where that offer letter comes in, because maybe you really like your people and you want to keep all the same people, but you're going to need some of your catering staff to become delivery drivers. So tell them that ahead of time so they have the option of considering whether they really want to be a delivery driver. Once we've sort of got our overall staffing plan in mind, then we get granular. We start thinking about employees individually. So you may want to consider unique or difficult to replace skill sets. You may want to, first of all, what do you need in the future? And then should any of those people be brought back sooner than later, just to make sure they don't get snatched up by someone else? If you have the best cake decorator in the country, you might want to bring that person back full time, ahead of others, just to make sure that they stay on your payroll and not somebody else's. Overall performance is always a good criteria to use. Hopefully you've got performance reviews or check-ins, something that sort of backs up your interpretation of overall performance. Seniority is another criteria that's very easy and pretty safe because it's quite quantitative, but it won't necessarily be your best option if you're trying to operate lean. Because it may not get to overall performance or skill sets. So think twice about seniority. It may work perfectly for you. You'll also want to consider, probably, willingness to do work outside of their usual assignments. So this goes back a bit to, is the caterer willing to be a delivery driver? Or the example I've been using is, let's say you're a small law office and you've got 4 paralegals and a receptionist. You need to bring back 2 of the paralegals for now, as well as the receptionist. But the receptionist is going to need some time off to care for a child whose daycare is closed all summer long. Well, are the 2 paralegals you plan to bring back, are they willing to sit at the front desk occasionally and answer the phones, or will they consider that beneath them and be unwilling? You might want to factor that in to which of the 4 paralegals you bring back. Just, things like that. And you may have a history. You may know who's willing to pitch in. If not, that's something you'd want to cover in the offer letter so people know what they're going to be expected to do, particularly if it's something that they will potentially consider beneath them, or sort of below their status at your organization. Preferably, we've got documentation for the reasons we are bringing some people back and not others. Like if you've got performance reviews, fantastic. If your organization hasn't been great about documenting things, never fear, you may actually have documentation that you're not even thinking about. So for instance, let's say you've got somebody who's always 6 minutes late to work every single day, and you don't write them up because you don't love it, but also it's not like the end of the world. Well, that might matter more to you now. You really need somebody who's going to be there on time. You want somebody who's going to be 6 minutes early, not 6 minutes late. You've never written this person up, but they're logging in every day. They're filling out their time card saying they're 6 minutes late, or punching in and the computer's logging them as 6 minutes late. So you may have documentation that you're not thinking about just based on some other systems you have in place. If you've got salespeople or people who are paid per unit, even if you're not sort of documenting that they're a top performer in their personnel file, that may well be on their pay stubs. So that's a direction you could look. Also, these last couple bullets require more digging, but if you've got emails and messenger conversations with employees about mistakes or deadlines missed, or the great job they did, under pressure, you can dig those things up to sort of support your choices. In a lot of cases, we are going to be relying on our managers for recommendations, and that makes perfect sense and is a good idea because your managers know more about their people than you do in most cases. But if you're the person ultimately responsible for layoffs or recalls, you want to make sure that your manager's reasons are solid and non-discriminatory. So I can't tell you how many times a week we get the call that's like, oh, we want to terminate this person, but they just asked for FMLA, or they just told us they were pregnant. And we ask, okay, well, do you have any documentation of this poor performance that you say they've had for months and months? And the answer is no, we have no documentation of poor performance. And juries can see right through that. They understand the concept of pretext, and that, this pregnant employee was probably not a poor performer, or you would have documented that. It's just that now you think she's going to be a lot of trouble going forward and may need accommodations and will need, leave to have the baby. And so you'd like to get rid of her now. People see through that stuff. Sometimes it's legitimate. Sometimes it is just a coincidence that somebody wanted FMLA leave or announced that they were pregnant around the time you were considering letting them go. That's a bad place to be in. That's why having documentation all along for poor performance is a really good idea. But at the end of the day, I'm getting at checking your manager's reasons. So particularly if they do not have sort of long-standing documentation, then we need to take an even closer look at why they've selected who they've selected. Things we, of course, don't want to consider, and most of this slide is going to be old hat for employers. We don't want to consider people's inclusion in protected classes. This is true all of the time about pretty much everything in employment, but I do think there are a few things on this list that are going to be particularly sticky post-COVID, or in the midst of COVID, I should say, if employers aren't watching out. So first up, age can get us in two ways. First, we might be thinking, oh, I'll bring back my older employees last. They'd like to stay furloughed during this time. Or I'll lay them off first so they can get unemployment insurance and not be exposed to risk. We don't want to do that, not just based on age. That's going to get us in trouble. There's another way that age can sneak up on us, though, and that's via a disparate impact claim. So if you're cutting all your high earners because your major priority is to reduce payroll, this will probably affect your older workers more than your younger workers. Just on average, older people make more than younger people. And the law, the Age Discrimination in Employment Act, kicks in at 20 or more employees and applies to employees who are only 40 or older. So it's a pretty broad law. And if we just cut all of our high earners, there's a really good chance we're going to be impacting people over 40 disproportionately. There is a defense to this, which is that you used a reasonable factor other than age. And you considered if there were other ways to achieve your objectives that would be less harmful to older workers. So at the end of the day, you may be, legally perfectly able to use that criteria, but if you are going that road, I would encourage you to talk to an attorney first. Going back to sort of, thinking that you're doing somebody a favor by laying them off first or bringing them back last, this goes for age as well as disabilities and high-risk conditions. You might feel like you're doing the right thing, and, morally, you may be doing the right thing, but it's really not your job to make health decisions for employees. So don't use what you know already based on, their inclusion in that protected class of being disabled or being over 40 to make your decisions. You decide based on job-related criteria. Are they good at this? Are they flexible? Do they have seniority? Do they have the skills I need? And then if when you extend that recall letter, they tell you, I need an accommodation, or I would like to stay furloughed longer if possible, then you can consider that. We definitely want to be granting those reasonable accommodations that we talked about earlier under the ADA. Fortunately, under our current situation, most reasonable accommodations that people ask for are going to be really inexpensive or possibly free and pretty simple. So if somebody wants to be recalled last, you can certainly consider that. If you've brought everybody back already, but they say, I would like, an unpaid leave right now because, I'm high risk and there's no way to reduce customer contact in my current job position. And they can't work from home, then we're looking at an extended unpaid leave. If they can work from home, that's an easy one. In fact, I would encourage you to have as many people as possible work from home, sort of full stop. Just the fewer people we have in any given space, the safer it's going to be. If somebody wants to wear additional PPE, let them. If they want to wear gloves and goggles and a face shield, that's reasonable. Again, you can't ask for a doctor's note to prove that they're high risk, but somebody looking goofy is not going to be considered an undue burden or an undue hardship on your business, so just let them do it. Same with taking additional hygiene or cleaning breaks. If they want to wash their hands 10 times a day, allow it. That's not a big deal, and it will be considered reasonable. Also, feel free to consider requests of employees who live with someone who is high risk. So there's nothing illegal about showing compassion or considering someone's reasons for wanting something as long as it's not based in their inclusion in a protected class, right? So discrimination is only a problem if it's based on one of those protected classes and it leads to an adverse employment action, so something bad, right? Employers can get really wound up thinking that treating anybody differently for any reason is going to get them in trouble, and that's just really not true. Like, let's say you've got someone asking to stay furloughed longer because their wife is undergoing chemotherapy. So she's immunocompromised, they want to reduce the risk there. There's no discrimination in allowing that. It's not based on that person's inclusion in a protected class, and it's not an adverse action. It's something you're doing that's nice as opposed to, negative. So do feel free to be compassionate in your choices. We've got a couple good questions here that I want to come back to. If you have any more questions, feel free to chat them in now, but I'm going to turn it over to Josh for a couple minutes to lead you through some resources we have available.
Yep. Thank you, Kara. And like Kara said, we'll make quick work of this and get right back to Kara for some more Q&A. Just want to make you aware of some resources that we've been working to deliver that might be useful to you during these current events. One is our return to work checklist. So this was a piece that we put together a few weeks ago as soon as we started hearing the murmurings of people wondering, what's the process? What are the considerations as we try to get back to work, as we look to reopen? So whether you're knee deep in reopening or you're just starting to think about it, we hope this is a really a framework to help you understand the many considerations and to provide some guidance around those. And this resource can be found in the HR Support Center. Next is a quick guide that actually our guest today, Kara, wrote this, but this is a quick start guide called Deciding Who to Recall from Furlough or Layoff. It just goes deeper into some of those considerations Kara has hit on today, but goes deeper into some of the discrimination types of issues that you need to be mindful of as you go through these processes. So these are found in the HR Support Center. if you have any questions on how or where you can access these alongside dozens of other COVID-related resources and thousands of other general HR and compliance resources, please reach out to your representative and we will be glad to help you with that. With that, we've got a few more minutes and a couple questions, so I will turn it back over to Kara.
All right, thank you. I realized that I'd actually answered most of the questions already. So there may be one left here for me to talk about, but again, if anybody's got any, feel free to shoot them my way right now. So somebody said that they didn't have to close and had work to do a while back, but 2 employees took a voluntary leave of absence due to COVID-19. And for a while there, they were busy, so they hired someone else to fill in for that, for those people who were out. Since then, work has slowed down and we don't need those people who were out on leave. I hope I'm interpreting this correctly. So what are our options in this situation? We have 25 employees, including these 2. So this will probably depend pretty heavily on whether their absence due to COVID-19 was a reasonable accommodation or not. So if they're covered by the ADA, and they wanted that extended leave because they are high risk, then they have job protection right now. And you'll sort of need to engage in the interactive process with them about whether, whether you're going to need them back ever. It gets a little sticky. I mean, let's be perfectly honest. Deciding when to let somebody go is always hard, but it's particularly hard if they're out on a protected leave, because if you let them go right now while they're taking an ADA leave, it could look like that's, an adverse employment action. That said, most leaves like that don't require that you keep someone on forever who you would have let go anyway, even if they hadn't been taking leave, because, for instance, you did a bunch of layoffs. So, I'm not your lawyer, and it would be legal advice to tell you exactly what to do in this situation. So if you do have a lawyer you can talk to, I would probably encourage you to do that. But I guess my takeaway is that you should be careful, and it's good that you're thinking about it with people who are taking protected leaves, because the burden is going to be higher to show that, we would have laid that person off anyway. All right, thank you all so much for joining us today. We finished just a couple minutes early. As a reminder, you will get a copy of the slide presentation, as well as an recording with audio of this whole thing. So if you're thinking that you'd like to revisit any of these slides, they will be coming your way. Thanks for joining us. Thank you for your participation, and have a great rest of the week.